If you're hurt on a construction site, you should contact an attorney as soon as possible after the injury. If you're not able to do so, you should have a family member do that, because a lot of times you need to do immediate investigation, secure evidence, talk to witnesses, and so getting an attorney on board right away is the best. When you're injured on a construction site, the first party that will be responsible for compensation is going to be the Department of Labor and Industries. That's made available to you for your medical bills and your time loss immediately. So that claim will be opened if you go to the hospital or the doctors. However, when somebody else is at fault for your injuries, then a claim can be made against them for full compensation. So more than what the department will pay. That will include your medical bills in full, your time loss in full, also your injuries and your pain and suffering. You're not going to get pain and suffering compensation through the Department of Labor and Industries. So you need to have an attorney on board to investigate to see if there's an at-fault party for which a claim can be made. That can be a general contractor on a job site. It can be another subcontractor on the job site. It could even be a products liability claim. So there's multiple ways to be compensated. The first part, again, is the Department of Labor and Industries, but then also potentially a third-party claim. If your coworker is responsible for your workplace injury, unfortunately, under Washington law, you cannot bring a claim against them. Just like you cannot sue your employer, there is Title 51 immunity that prevents you from suing an employer or coworker under most cases. And so that immunity means that the Department of Labor and Industries is available to compensate you, so you can't bring a claim against your employer or coworker. However, a good personal injury attorney should be contacted to investigate if there's any other potential at-fault party, such as a general contractor. The general contractor may have failed to ensure safety on the job site or other safety measures, and they could be found at fault or negligent for failing to do that. When you have a construction injury, you should hire an attorney, and you can hire two different attorneys. So a labor and industry attorney can be retained for just your labor and industry claim, and you can hire a separate different attorney for your injury claim, your third-party claim. The most important thing is to make sure that you have a good attorney helping you on your third-party claim that knows construction cases and can do the full investigation, get the experts involved, interview witnesses, and do the work that needs to be done to help you out. If you have two separate attorneys, one handling your labor and industry claim and the other one handling your construction claim, we will work hand in hand with your L&I attorney. Your L&I attorney will be working on your medical and your time loss, and they will help us, work through your claim. But what's really important to know is that you do not need to wait to hire a third-party attorney for your construction injury claim. The Department of Labor and Industries might tell you you should wait until your claim closes. You should have an attorney right away to help protect your claim, build up your claim for damages, and then present your claim for resolution at the appropriate time. At GLP Attorneys, we'll be with you from injury to recovery.